And this is The Extra on KRDO News Radio 105.5 FM, 1240 AM. Catherine Hammond, no stranger to KRDO's Extra, is back with us. A lot to talk about. Catherine, Happy New Year.
Happy New Year to you, Mike.
And I start out with a Happy New Year because one of the things I'm going to ask you as we go into a new year, has anything changed that we need to talk about specifically? Now, Catherine specializes in, getting wills done, if you have to make end-of-life decisions, family planning, those kinds of things, estate planning. So we're going to talk about all that this morning with Catherine. So a lot to talk about, and we could probably spend hours on this.
Absolutely, we could.
Now, there's a new book, Planning Your Legacy, a guide to preserving your personal and financial legacy. And you wrote the book?
I wrote the book.
All right.
I partnered with the founders of the American Academy of Estate Planning Attorneys to do a book specific to Colorado about estate planning.
And that's very important because, as I understand it, I've heard it said that each state is different.
Yes.
Okay.
There are a lot of principles that are the same, and a lot of issues and concerns that people have around estate planning that are the same, but there's a little bit of difference state to state, even in silly little things like execution requirements for a will. For example, in California, they don't require a notary. In most other states, they do. And so when people move here from California, they have a will that's not notarized. It's not going to work quite as smoothly in Colorado as it would back in California. So there are some state-to-state differences.
And when someone passes away, you mentioned smoothly. Most of us have lost a family member at one time or another, grandparents, something like that. And, you're grieving. You're trying to get things done. There's so many things. The last thing you want to be worrying about is the legal aspects of the will wasn't done right, correct?
I take a deep breath when you say that, because that really is the core of it, Mike. It's about making things, minimizing the headache and the heartache when somebody passes away, because there's so much emotional and practical stuff to deal with. If we can minimize the legal headache, then it really frees people up to grieve and to take care of the other practical things that they have to take care of.
Let me see if I remember this correctly. If you die without a will, is it called intestate? Is that the word? All right.
Yes.
So I did pay attention in my pre-law class in college. That's about all I remember. A couple of things. Nowhere near a lawyer, of course, but I just wanted to throw that out. So you don't want to die intestate? If you have assets.
That's an interesting question, Mike. I have met with some people in my legal career who, when we talked about what they really want to have happen, is exactly what the state would do when they die anyway. And so for some people, I'd say it's less important. I always think it's good to have at least a very basic will that expresses who you want to act as your personal representative and how you want things to go. But for some people, it's more important than for others. That the important thing is understanding what you want to have happen and what would happen if you didn't have anything in place. And typically it takes a lawyer to figure out all the nuances of that.
Dave Ramsey, who has heard 1 to 4, I've often heard him talk about family members that may be misbehaving. You may want to make sure those family members don't get anything.
Yeah. And, one of the interesting things there is that some family members behave quite well while we're living, and then the second we pass away, things explode. And there are, sometimes the day that somebody dies, there are miscellaneous children going to the house and taking things out of the house and hiding things from each other and accusing each other and distrusting each other and getting ugly. And so if only we could figure out who the misbehaviors are ahead of time, that would be fabulous, but sometimes it's hard to predict. So setting things up in a way to minimize all of that, maintaining family harmony is one of the most important things for a lot of our clients.
Now, I would like to ask you, an executor of the will, first of all, what does the executor do? Do you have to have one, and does it have to be someone who's in the will?
So first of all, an executor in Colorado, our formal name for that is a personal representative. And I think your first question was, do you have to have one? Well, if your estate will have to go through probate, then yes, you will need to have a personal representative, who is put in place by the court. So you can nominate somebody in your will. That doesn't actually appoint them. the court still has to get involved to make them the personal representative and give them the power to do the things that they need to do. So if you're going to have to go through probate, which most people do, if you own a house when you die, then you're going to have to go through probate unless your joint tenant is still living. But at some point, most people go through probate, particularly if they're homeowners. And so yes, you have to have a personal representative to take it through the probate process. I can't remember the other questions that you had in there.
Well, does it have to be someone who's named in the will?
So it should be somebody that you nominate in the will. Mm-hmm. It doesn't have to be somebody who is playing any other role in your will. So it doesn't have to be a beneficiary or one of your children or anything like that. It can be a friend. It can be one of your children. It can be a stranger. There are professionals who will act as your personal representative as well.
Now, in Colorado, you said it's called personal representative. So, i.e., personal representative or executor. What do they do and what can't they do?
So the executor or personal representative is responsible for, first of all, figuring out everything that you own when you die and getting valuations on all of your property, and then making sure that all of your creditors are paid in accordance with state law or federal law where that applies, and then making sure that things get distributed either the way that you said that you wanted them to go in your will, or if you didn't leave a will, however state law would have them go.
So if you have $1,000, just for round numbers, and you owe $900, that you have to pay the $900, and then there's $100 left to be split up.
That could be true. Correct.
Okay. Interesting.
Yes.
So the creditors get they're in line too.
They are, and in certain situations, family members can get some of the money first. So, but if all you have left is $1,000, yeah.
I understand. All right, we will continue. We're going to go back and talk about Catherine's book, and she's got some free copies available if you attend her workshops. We'll find out when those are coming up. A lot more. Do you have a question for Catherine Hammond? Call 473-1240 right now. TJ, our producer, will answer it. He'll take your question in. We'll ask Catherine on the air, and we'll get your question answered for you, hopefully to your satisfaction. So 473-1240 is the number to call if you have a question you'd like to ask. It is 9:15. This is KRDO News Radio's Extra. And it is 9:19. Mike Lewis with you on the Extra. We have some questions coming in. We appreciate all the phone calls that just popped up just a couple of moments ago. TJ is compiling those. We'll get them answered and asked and answered in just a couple of moments with Catherine. Catherine Hammond with the Hammond Law Group. Catherine, if folks are listening to you and at some point maybe they want to contact you directly, how do they do that?
You can go to our website at coloradoestateplan.com or just call our office, 719-520-1474. And we do have some basic estate planning workshops going on right now this Saturday morning at 10 o'clock and then again on February 7th and February 11th. And all that information is on our website.
All right, sounds good. Well, what are some of the biggest misconceptions about estate planning, Catherine?
You know, one of the things that I consistently hear is people saying, I don't have that much stuff, so I don't need an estate plan. Mm-hmm. And I think there are a couple of misconceptions within that. First of all, estate planning is just figuring out what documents you need in order to take care of things if you become disabled and when you die. So it's not that it has to be fancy, but there are some basic documents that pretty much everybody needs. And it's whether you have a lot of stuff or whether you have very little or no stuff. The possibility of becoming incapacitated, having a stroke or dementia or a brain injury is there for all of us, no matter what we have. And getting just a basic financial power of attorney and medical directives in place can really, really change things and make sure that you get taken care of by the people you want and that they have the power to take care of things if one of those kinds of tragedies happens to you. And then when you die, a will is just a form of estate planning. So most people could benefit from a will. There are a lot of folks who don't want to have to go through probate and they end up doing a trust. But no matter how much money you have, some sort of estate planning is helpful. A lot of people think they only need an estate plan if they're old. Until they're 70, they probably aren't going to die today, so probably they don't need an estate plan or don't need to update their estate plan. All the time, every day, we hear stories about people who die completely unexpectedly. And so death and disability don't just happen to old people. So.
Well, especially if you have a family, if you have kids, maybe
Right.
and especially if you're a single parent. That's something you really do need to think about. Who's going to take care of the kids? And if you're married, even if you're, together and, both parents die in an accident, that to me, that is just absolutely key. Who do you trust taking care of your kids?
That's interesting because so many young parents don't think that they need to have their estate planning taken care of. There's no time in our life when it's more important because of all of those issues. Making sure that the person you choose is going to be raising your kids. A lot of people can't think of a perfect person to raise their kids, but you can think of somebody who's better than the judge could come up with if you don't choose anybody. And then making sure that the money that you do leave behind, even if you just have, let's say, $100,000 in life insurance, making sure that that money is actually used for your kids and not handed to them when they turn 18, that they're going to go squander on a fast car and, a lot of fun.
You bring up life insurance. I remember being told a long time ago when I was in the Navy, we had the life insurance through the Navy. They told us when we signed up for it, doesn't matter what your will says, it's the beneficiary that you put on your policy. So you may think your will is going to go one way, but if you list on your beneficiary for the policy, the will does not override that. Is that correct?
That's absolutely correct.
So if something changed in your life when you bought your life insurance policy, you got to remember to update that too, just not the will.
Yeah, that's one of the reasons why we always recommend to people that you go back to your estate planning attorney at least every few years and just sit down and have a conversation. A good estate planning attorney will check in on all of those things. We offer our clients a free checkup just to make sure that all those little pieces come together. And one of the places where we see the biggest problems with that is blended families. If you come into a marriage and you have kids from a previous marriage, people will put their new house in joint tenancy, for example, but their will says that some of their money should go to their kids when they die. Well, if everything is owned in joint tenancy with your new spouse, it's the same thing as the life insurance beneficiary. It's not going to go to your kids, even though your will says you want something to go to your kids. If it's all owned in joint tenancy with your new spouse, it all goes to your new spouse and your kids get completely disinherited.
Okay, so again, this is why you need to speak to an attorney. We did have a couple of questions come in, Catherine. We're going to get to that after the news update. So if you're listening right now, your questions are going to be asked and answered in just a couple of moments. If you have a question for Catherine, 473-1240. How often do you get to ask an attorney something and there's no charge? Well, it's happening today on KRDO News Radio. Catherine Hammond is our guest. I would like to go back to the book that you wrote. We started with that. You said free copies are available at workshops. So if you attend a workshop, you're going to be able to leave with that workbook.
Absolutely.
All right.
Yep.
And we'll be listing some of the workshops again. You mentioned it a few minutes ago, but we'll give you the times and dates again that you can meet with Catherine. And again, get the information you need. Because what is the saying? Death and taxes, it's something we all face. It is 9:25 on KRDO News Radio, 105.5 FM, 1240 AM. Catherine Hammond will continue. I'm going to get those questions from TJ. We'll get them asked in a moment. This is KRDO's Morning News. We've got a quick news update coming in a moment. The time, 9:25. KRDO News Radio's Extra, sponsored in part by Liberty Mutual. You have enough things to worry about. Insurance shouldn't be one of them. You can leave worry behind when Liberty stands with you. Liberty Mutual Insurance. All right, let's get a couple of these questions asked and answered. And thank you. Some great questions this morning, Catherine, from our listeners. We'll start off with Ryan. Now, Ryan says that I think it's his sister on disability. Grandmother's getting ready to give the sister, or has just done, or will be, giving them $10,000. How does that affect the disability?
Right. That's a really, really important question. So if grandma has this in her will, that there's money going to her granddaughter, and her granddaughter is on either SSI or Medicaid, which are need-based government assistance programs, then if she receives $10,000, she would get kicked off of those benefits. have to spend down the money until her total money is down below $2,000, and then she has to reapply for whatever benefits she used to have. So it depends on a couple of things. First of all, what kind of benefits she's receiving, what kind of disability benefits. SSDI is not need-based in the same way that SSI is. SSI we'd have to worry about. Medicaid we have to worry about. So if this is a situation where grandma is still living and is considering doing this, there are some other better ways to do it. If it's already happened, talk to an attorney and they can help guide you through. You could probably do a spend down of that money in the same month that it's received and have it not disqualify her from her government benefits. So there are still options whether grandma's still living or not.
Okay, great question, Ryan. Thank you. Wendy asks, is there a way to pass her home to her son before she dies?
Boy, that is interesting. My first question would be, why is it that you want to pass your home to your son before you die? Some people do that so that son won't have to go through probate. If that's the case, giving it to them beforehand is not the way that I would recommend doing that. First of all, once you gift something to somebody else, anything that happens to son now happens to your house. So let's say he gets into an accident, not even his fault, and he gets sued. They could take your house. Let's say son is married and he gets divorced. It's possible that his future ex-wife could end up with half of your house. All kinds of problems with that. There are also issues if you're wanting to do that for Medicaid planning purposes. Some people are worried that the nursing home is going to take absolutely everything if they have to go to a nursing home. That's a really valid concern. It costs about $90,000 a year to live in a nursing home these days. And so some people want to give away their assets so that it doesn't all end up with a nursing home. I have some of those same concerns. If you give it away, all those bad things could happen to your house. And you have to be careful about how and when you give things because that could end up disqualifying you from Medicaid. So no matter what the reason is, I would really recommend doing just a free consultation with an attorney to talk through what it is that you're really trying to accomplish, what are the pros and cons in your situation, because it's different in every family and every situation.
Well, if you're a little humming in the background, we're doing some remodeling here at KRDO, so putting a fresh coat of paint on the place, which is always a good thing. All right, well, speaking of nursing homes, this is perfect for the next question. Susan calls in, and this is an interesting situation. Her mother is in a nursing home in the state of Nebraska. The mom, she says, wants to come here and live with her in Colorado. The brother has the mom's power of attorney, and the brother says, no, she can't leave. So does mom have any options? Does daughter have any options?
Yeah. There are several things that we don't know about this situation, so I can't give a definitive answer. But a couple of questions would be, first of all, is mom still competent to make her own decisions? Because if she can communicate her own decisions, even if she doesn't have the ability to manage all of her own financial affairs, if she can still communicate her health care wishes, then she gets to make the decision about where she lives. So that's really important. It doesn't matter who's on the power of attorney. The other thing is, what kind of power of attorney are we talking about? Is this a financial power of attorney? Is it a healthcare power of attorney? A financial power of attorney would not be the document that decides who gets to decide where she lives. That would be a healthcare power of attorney. And it might be, in different states, we have different names for documents and different ways that they work. So it depends on exactly what documents she has in place and what document son is named on. Now, in addition to that, if there's something that would be better for mom about living in Colorado, and there's a problem with her being where she currently is, there might be a way for daughter to bring that up with brother or through the legal system to make that happen. So really, I'd recommend consulting with an attorney.
And you started off by saying if mom is still competent and can make decisions, she could undo her power of attorney, couldn't you? Because those aren't.
Absolutely.
So you can cancel a power of attorney at any time. Is that correct?
Right.
Okay.
As long as you're competent.
As long as you're competent. Yep. Okay. All right. This next question is from Paul. Paul and his father co-signed on a house, and they are concerned about some issues with that. And that may not be an estate planning question, though, if I understand what your thoughts on that.
Right. So co-signing on a house, first of all, I don't know. I'm assuming that they co-own the house. They co-signed on the loan, and maybe they also co-own the house. And I think Paul's question was about capital gains taxes and how that works. There are a lot of details that we don't have that make me unable to answer that question specifically. But I'd say that would be a question first maybe to talk to your tax professional about if you have a CPA or whoever you use to do your taxes. Give them the details about who owns the property, who co-signed on the property. One of the things that we want to make sure happens. Oh, and this goes back to the last question also about gifting property while you're living. Capital gains taxes depend on the value of the property when you took title and your basis in the property. And so with this one, I think the original question had to do with capital gains taxes. We don't have enough information to answer that. If you're gifting your house during your lifetime, you're also potentially going to be adding on some capital gains taxes that aren't necessary. If you leave things to your loved ones when you die, the way the law works today is that they get a stepped up basis. Their basis in the property for tax purposes is the date of death value. So if you bought it for $50,000 and now it's worth $200,000, they start as if it was originally $200,000. They only have to pay taxes on any increase after that. If you gift it to your son today, then he would take it with the, let's say, $50,000 basis. And if he turns around and sells it, he's going to have to pay capital gains taxes on that $150,000 gain.
Boy, that's a significant amount of taxes, too. I mean, that
right.
could be, yeah.
Oh, it definitely could be.
Especially if they've been in the home for a number of years. Let's say let's say the parents owned it for 30, 40 years. You could see significant increases. All right.
So, yeah, important to think through.
This is why you really do need to see a tax professional. You need to see an attorney for the legal aspects of this. And we'll continue with Catherine Hammond in just a couple of moments. Catherine, how do people reach you?
You can go to our website, coloradoestateplan.com, or call our office at 719-520-1474.
All right, our guest, Catherine Hammond. We'll continue in a moment. This is KRDO News Radio's Extra. It's 9:44. Congratulations to Ellen. Say hi and let them know KRDO sent you when you go to Captain D's to enjoy that lunch or dinner. We have just a few more minutes left with our guest today, Catherine Hammond, on the Extra. And Catherine, we have another question that came in. And Kim, thank you for calling. Thank you for listening. The question from Kim is, her sister and her co-own a home, and her sister is on Medicare, or Medicaid. Now, when she dies, does she have to sell the home or give anything back to the government? I think that's the gist of it.
Yeah, it's a little bit tricky there. So if the sister who's on Medicaid was the only owner of the home, then typically Medicaid would put a lien on the home and they would be able to collect up to the amount that they've paid for sister's care after she passes away when she leaves the home. If the home is in joint tenancy, it depends on when it was put in joint tenancy and potentially whether sister is providing care. If it was in joint tenancy before sister went on to Medicaid, then probably Medicaid is not going to be able to collect anything from the home. It just depends on those factors.
Right. So once again, a lot of questions, and you need a little bit more specific information to get the total answer, but it gives you an idea.
Yeah, and you might be able to get that answer from Medicaid, or if not, you can talk to an attorney who does Medicaid planning.
Okay, great question. And again, Kim, thank you for calling, 473-1240. I would like to go back, because we talked about it last time, but I think it's an important topic, trust. You hear about trust. What is a trust in general?
A trust is really just an empty theoretical box, kind of like your own personal treasure chest that you put all of your stuff into while you're living, so that it's a neater package to leave to your loved ones when you pass away. It's a lot easier for them to manage. Typically, it keeps things out of court, so you're not stuck paying lawyers and dealing with judges and the whole legal system which is one of the big reasons why so many people do trust these days, is so that lawyers are expensive. And it's a lot more expensive typically to go through probate if you have a lawyer handling the probate than it is to hire a lawyer to do a trust in the first place. So a trust can eliminate all that hassle. And then also you can set it up so that after you die and the money is going, let's say you have 3 kids and one of them is still young, you don't want them to get the money all at once. The trust can have that money handed out over time so that they use it well. Maybe you have a daughter who's great, but a son-in-law that you don't like so much and their marriage is a little sticky. You want to make sure that your son-in-law doesn't end up with that money. You can set it up in your trust to make sure that even if they get divorced in the future, your daughter inherits the house and then husband files for divorce, he can't make any claim against the house or the money that you left behind.
Can trusts be changed once they're started?
Absolutely. As long as you're living and competent, you can change if it's a revocable living trust, you can change it whenever you want. Some people do an irrevocable trust in order to minimize what has to go to a nursing home or for Medicaid planning purposes or for asset protection purposes if you're afraid of getting sued. But as long as it's a revocable trust, that's what most people do, you can change it whenever you want.
Okay, great, good advice, good questions. When are you? I know you do this throughout the year. You have seminars where people can sit down and listen to your presentation and also ask questions. When are those coming up?
We just had a couple of workshops yesterday. Lots of people making New Year's resolutions to get their estate plans put in place. We have another workshop coming up this Saturday morning, January 14th at 10 o'clock. And then again, we have them on Tuesday, February 7th in the afternoon and evening, and on Saturday morning, February 11th. Again, there's lots of people wanting to get this taken care of finally in 2017.
Okay, and you can visit the website and see when those are coming up throughout the year, correct?
Absolutely. Call our office or go to coloradoestateplan.com.
All right, how long, we have just a couple more minutes left with you, Catherine. When a person dies and their will and their estate goes through probate, how long does that generally take if everything is, if it's a clean, if there are no problems?
If there are no problems, which is a little bit rare, they say the average probate takes somewhere between 9 and 24 months in Colorado.
Whoa.
Right. So there are situations where it can get done in 6 months, maybe a tiny bit less. That's not the norm. Normally, it's more like 9 to 12 months, even for a very basic estate with no fighting. Once you add in any kind of disagreement between the people who are left behind, then you're looking at typically a couple of years or more.
I had no idea that they could last 2 years like that. I guess if it's being contested, I could see where that could go on, because then you have to basically get in front of the judge, and the judge is going to ultimately decide, correct?
Right. And once you get lawyers involved, we end up filing motions disagreeing with everything that the other person did, and then everybody has to file their motion, their response, their reply, and then have a hearing, and it can drag on and on and on. And
if there's not a whole lot of money in the estate, it sounds like by the time the lawyers get done, there could be even less money available for the family.
I've had a lot of people over the years tell me that when their parents died, the lawyer either got everything or almost everything. Okay. And I think it's tragic. And
that's why you can visit with Catherine Hammond and make everything, take care of everything in advance, maybe a trust if that's right for you, and avoid all these problems.
Right. I say avoid the lawyers.
Okay. And you're hearing, and she's a lawyer telling you to avoid her. There you go. All right. Catherine Hammond with the Hammond Law Group. We'll get you back next month on KRDO News Radio's Extra. Always great, always informative. Thank you for your questions, everyone who called in today. We'll ask questions next time Catherine is with us on the Extra. Coming up in just a couple of moments, we've got a news update. Then we've got Tom Martino, the troubleshooter. If you're having a problem with some businesses in the area, Tom will help you solve those problems. And on the other side of that issue, if you're doing a business with someone who's doing a great job, Tom wants to know about that too. He likes to give folks a pat on the back. He'll give you some recommendations. Folks are dealing with roofing issues right now in the Colorado Springs area because of the damaging winds. KRDO News Time is 9:55. So we've got ABC News coming your way at 10 o'clock. Then we've got Tom Martino, the troubleshooter, the new news, and Dave Ramsey coming up at 1 o'clock. By the way, there's going to be a news conference at noon from Dove Valley with the new coach of the Broncos. That'll be carried live on KRDO News Radio. They're going to start the newscast with that. This is KRDO's Extra.